One. One, two. Good morning, all. I just want to make a quick announcement, or actually it's a reminder of the protocols in place for this auditorium. Importantly, number one, there is a red line on both sides of the auditorium in the aisles. No member of the public or the media is allowed to cross that red line. Secondly, members of the public, you are to confine yourselves to the public gallery, the benches in between that aisle up there, just below the public gallery, and the front here is reserved for media.
You would have been able to respond to. Truth be told, actually, there wasn't even a need for a replying affidavit. You could just have put together written submissions, and you would not have been out of time. So I have difficulty understanding the difficulties that you say you had.
Chair, yes, to the effect that it relates to legal issues, but there's also information during their consultation, as limited as it was, where it became clear to us, having had sight of the replying affidavit, that there's factual elements that need to be addressed that relates to documentation which we did not, or rather they did not have at hand when they were consulting. To say to that, we received a further document this morning from Mr. Matlala that he was unable to go and obtain from his the room or the prison cell that he's been kept in. And it speaks directly to the issues that would have to address in terms of the legal points. So that's
very peripheral. Those issues about whether Mr. Matlala received certain documents a day or two before the hearing of his testimony, those are very peripheral issues, and they have nothing to do with the legal questions that Mr. Matlala's application raises. So I think my point stands.
Chair, I did not hear the last few words that you said.
I said I think my point stands.
Noted, Chair. Noted.
New Maybelline Serum Lipstick with a hyaluronic acid and oil blend that drenches lips in up to 35% more hydration from Maybelline, New York.
In terms of the entire process and how we found ourselves here today, I can't explain it any further than what I already have, Chair. And as I stated earlier on, I can only beg this commission to take into consideration and to give us a chance up until
I'm listening, you may continue.
Thank you, Chair.
Let me indicate what my inclination is, which you would obviously have seen in the directive that I issued. In fact, I sent it out to the attorneys after 6 a.m. I don't know what time they instructing them to write a letter to Mr. Matlala's attorneys. I don't know what time that email was sent, but I gave the instruction after 6 a.m. My inclination is for Mr. Matlala's application to be argued now, this morning. That's my inclination. What's your response to that?
Chair, my application for a standout from tomorrow, still, that is the position that we're taking. If the chairperson could grant us that opportunity to come before this commission prepared, and at least for you to have sight on paper, at minimum, some of the case laws, because we do believe that this is an issue that has never been dealt with by any commission in South Africa. Speaking to the position that we find Mr. Matlala in, and we do deem it imperative that you have sides, yes, of the legal argument, but also the case law that we rely on to make out this argument. I don't know how efficient it will be, given that it's a constitutional issue in the position that we find ourselves in, and we've tried to look and research to see internationally if we could find something that could give us guidance on this here, on the issue that we intend on arguing. And we do believe that it would be of a benefit to the Commission to have sight of the case law in our written submissions, Chair. I don't know how beneficial it would be if I only argue this and you are unable to make reference to those cases and the paragraphs and see exactly, is she applying herself correctly? Do you agree with me, yes or no? And what's the position? And I think perhaps that's the consideration you'd have to make in finality, which is one, this is a position that we believe any commission here in South Africa has never had to deal with and answer and consider. And perhaps it would be beneficial to have consideration of the cases that we would like to refer to or refer the Commission to, Chair. Thank you.
Thank you. I will go back to the question that I asked about this being a legal question. This is something that Ms. Vandenheever was quite passionate about from the day of the last appearance. She referred a number of times to an application where points in limine would be raised. From the moment that you start thinking about bringing an application in which you are going to raise points in limine, you already know what the law that supports you is. So it should have been a matter of relative ease. In fact, even easier for you, Ms. Vandenheever, as Mr. Matlala's lawyers, to argue the law than it would be for the evidence leaders on whom you are springing these points in limine. So I'm not sure that I follow your response. Can you tell me why written submissions were not or could not be filed on legal issues that were the start of all this, legal issues that you thought of even before commencing this the process that we have before us this morning? And underlined, you were ready with the law right from the beginning. Otherwise, you would not have even considered bringing an application in which points in limine were being raised.
Chair, I can only take you back to the fact that from our consideration was that it was imperative for us to prepare the replying affidavit. My apologies. From our considerations, we found it or deemed it imperative for us to prepare the replying affidavit and to get further instructions from Mr. Matlala with regards to the position that we're taking. And I do note the point that you're making, that perhaps what we could have done in the interim was prepare the heads of argument to assist the Commission and have them filed on time. I take note of that, Chair. But that was a delay that came as a result of the consultation, the considerations that we had to make, which is that given the answering affidavit, we deem it important to get further instructions from client with regards to the replying affidavit before we proceed with penning down the position that we've taken with regards to the application. That's as far as I can take it, Chair.
Morning, Ms. Missy. The point is simply this. Mr. Matlala would not have assisted with the law because the law is for lawyers to research and to argue. He could only have assisted with the facts and the giving of instructions as far as whether he wants to persist his application. But the law is for the lawyers, and the moment they advised him to bring this application, this was the time to start considering, especially being aware of the strict timelines under which this commission operates. We simply cannot afford a wasted day because our schedule is already very tight. And that is the difficulty we find ourselves in.
Commissioner, it goes back to the considerations that we made. If I have to make further submissions, then I have to make up stories, and I'm not prepared to do so. What I have explained to the Commission is the step-by-step process that we've gone through, and I do take note of the points that both yourself and Chairperson are raising. Thank you.
Yes, Ms. Hassim. Perhaps let me just ask this quick question of Ms. Sillo. How much longer do you think Mr. Matlala's testimony will take? I know those estimates have regularly been overshot.
I know, Chair, and in this case, it shall be particularly so because Mr. Matlala's testimony in truth hasn't even begun. So all he's done is read his statement into the record, which he has sort of supplemented through this application. I guess he may want to place that also on record. We had anticipated a minimum of 2 days after he has placed his statements on record, Chair.
So today and tomorrow?
Today and tomorrow. A minimum of 2 days. Thank you, Chair.
All right, thank you, Mr. Yes, Ms. Hassim.
Chair, just a few responses to what Ms. Nisi has submitted. The first is, and just to correct some of the facts. The first point relates to the filing of the founding affidavit. It was due at 10 a.m. on Friday. This was subsequent to the directive of the chair that was made on Monday. So there was a long period between Monday and Friday for the purposes of consultation with their client before the filing of the first affidavit. So the long explanation that was given about the difficulties with accessing the client in correctional services doesn't really assist in relation to the founding affidavit because there was sufficient time. But it's not only sufficient time from the period between Monday and Friday last week. Mr. Matlala's legal representatives have been raising this issue for some time, prior even to Monday. They are aware of the categories of evidence that the evidence leaders wish to canvass with him in questioning. They've known this since at least March of this year. So this application could have been brought much sooner. And so all of the time, in fact, that was available to Mr. Matlala's legal team extends over months, not over days. So that's just to address the founding affidavit and the explanation for the lateness, which I say doesn't assist Mr. Matlala's team. The second point is about the heads. And I'm not going to repeat it because, Chair, you've made the point and Commissioner Khumalo has made the point. Those are legal, that's legal argument. There's a legal team that's assisting Mr. Matlala. The heads of argument could have been submitted timeously and they weren't. There was no need for consultation in relation to the heads of argument. Preliminary points are by their nature legal submissions. The second...
Please continue.
On the point of the legal submissions, you would have seen from our answering affidavit that we set out the legal principles. It's not true that this is not circumstances that have arisen in the commission before. That is not correct. The authority that we have submitted to the commission that we say is the controlling authority is the Secretary of the Judicial Commission versus Zuma, the Constitutional Court judgment, and specifically the judgment by Justice Jafta, which was a unanimous judgment. And we referred to paragraphs of that judgment, which we say is the governing authority to be considered here. So the law on how one should deal with the assertion of the privilege against self-incrimination in a commission.
Just explain the point about or the judgment having been unanimous?
The judgment by Justice Jafta on the point of self-incrimination and the assertion of the privilege against self-incrimination in a commission of inquiry. So that's the judgment on which we have relied. We set out the legal principles in the answering affidavit even before we filed our heads. That's just in relation to the point on the privilege, the section 3, subsection 4 point. The second legal point was in relation to unconstitutionally obtained evidence. And there too, we set out the legal principles in the answering affidavit even before we got to the heads of argument. And the point I'm making is that these are legal submissions. That's why our affidavit sets out the legal principles. And there we explained why the argument that Mr. Matlala is entitled to blanket immunity from questioning in relation to broad categories of topics is not available. It's not a competent relief that they were seeking from this commission. That was already set out in our answering affidavit. So it's not correct that there's no law on this and that they needed to have more time. Quite apart from the important points that you and Commissioner Kumalo have already made, that this is something that's been brewing for some time by Ms. van den Heerfer. The third point is just in relation to, I just want to correct the Dlamini affidavit. It's true that the Dlamini affidavit was filed with the commission and submitted to Mr. Matlala's legal team this weekend, but that's not part of the application that's before the commission today. It's entirely separate, and that should not hold up the argument on the application. Those actually are my submissions, Chair. I think that the commission will decide on how much of time, if at all, any time is to be granted to my learned friends. But the argument is there from our side. We are ready to respond. Our concern as evidence leaders, as we've set it out in the heads of argument, we wish to have the application dismissed, and we want the questioning of Mr. Matlala to proceed immediately because time is short.
Thank you, Ms. Hassim.
I'm sorry, Chair. There's one last point that I've forgotten, and it's sitting here in front of me. I'm sorry about this, Chair, but we also received communication yesterday, and this is something that perhaps my learned friend will want to consider and advise on. It wasn't apparent to us yesterday whether, in fact, Mr. Matlala's legal representatives were abandoning the application. Because last night at 20:51, we received an email from his attorneys. And the email says the following, if I may read it into the record, Chair. It says, "Good evening, evidence leader. We respectfully request your urgent written clarification regarding the scope of permissible questions on record. As discussed yesterday, certain questions are excluded due to the pending criminal matter. We attempted to send an email to this effect, but it appears our system may be experiencing technical difficulties. To avoid any procedural uncertainty, kindly confirm in writing which questions may be asked and which are excluded. This confirmation is necessary to ensure proper management of the record and safeguard procedural fairness. We would appreciate your written response." The response to this letter was as follows. Greetings and salutations, and then please note that until the commissioners rule otherwise, there are no questions relevant to the terms of reference which we treat as being impermissible. So that was the correspondence between the two sides yesterday. It was quite confusing to us what the meaning of this was, because what it suggests is a request for the questions, what questions we intend to pose. From that, we thought that maybe the approach being taken is to proceed on the basis of pose the question, and then the privilege will be asserted once questions are posed. And so I think that my learned friend may need to just also clarify that.
Ms. Missy, does the letter mean that the application is abandoned, or what does it mean?
Chair, no, the application is not abandoned. The reason for the email is we're trying to anticipate where the ruling perhaps doesn't go in our way. And Chair, based on the ruling that you would make, then Mr. Matlala would then have to apply the right against self-incrimination as and when the questions come. And I believe the thought process was that when it comes to those topics that he cannot claim privilege over, then what are those topics that we can anticipate an engagement over so we can prepare with regards to that? It was not to indicate in any shape or form to my learned friends that we are abandoning the application.
Yes, I must say that.
Last minute mom, sporty mom, bougie mom, or aesthetic mom. Whichever mom you are, pour a little fun into every day with Steri Stumpy.
Which would be something that's unheard of and in fact quite bluntly very strange.
Chair, I do take note of the wording as well, the confusion that would have come from it, but my understanding was that I think the attempt was to ask under...
We see counsel outside, please. Refused Mr. Matlala's application must be argued at 12 midday today. Let's adjourn and resume at 12 midday.
from Mr. Matlala, having heard the engagement that we heard prior to the stand down. And the position that is taken is that he feels that it's unfair that the commission is putting him in a position where he has to proceed where his lead counsel, one, is not here, obviously not of her own doing, but because of an illness that became rather sudden in the manner that it's attacked her. Two, because we've intimated that we've not prepared our heads in written submission, he's of the view that he's not comfortable to proceed because that implies that we're not properly, we're not fully prepared to represent him. And so his instructions are that if the commission is not willing to at least grant us this afternoon to ensure that we have those documents before you and that we have our heads put together properly, in the alternative, he has no option but to instruct us to bring an application interdicting the proceedings of this hearing pending the review of the decision for us not to get a stand down until tomorrow.
You said something about this afternoon and now at the tail end you say something about tomorrow. Can you please clarify?
Chair, you'd recall when we began our discussion earlier on, we were requesting that the commission stand us down until tomorrow morning, at which point we had made an undertaking that we would have served you with our replying affidavit and our heads of argument. And so what the instructions are is that our application on an urgent basis would interdict the proceedings of the hearing or him giving testimony pending the reviewing of the ruling that you would have made, which is that we must proceed with arguing this matter because he's of the view that it's unfair that he's been placed in this position where he has to proceed without Van der Heerwe, who is his lead counsel, and without heads of arguments before you, which he believes then implies that we are not properly prepared and we're being strong-armed into proceeding.
Now, this time around, you've not said anything about the afternoon. It's what you said about the afternoon that I want to understand.
Yes, Chair, what I meant is that if we stand down now, it'll imply that we only have this afternoon and evening, I suppose, to ensure that we get the documents before the commission. So that's what the afternoon referred to, that if you do change your ruling into us standing down or postponing until tomorrow, it means that it's just this afternoon that would have to ensure that we have bring the documents or serve them on the commission and the evidence leaders. That's what the afternoon was.
Oh, you keep repeating that because you don't have your written submissions, you are not ready. Written submissions, yes, they do assist legal representatives, but in the main, written submissions are prepared for the assistance of the decision maker and not so much the arguer. Do you want to address us on that distinction? So those would more have been of use to us, but seeing that the written submissions are not there, we are prepared to forego the assistance we would have received from your written submissions. So as I say, it's more for us than for you.
Chairperson, having engaged with client afterwards stood down, and obviously with what he had heard during our discussion, his instructions to us is that his observations and his views is that if Ms. Van der Heerwe is not here and we have not prepared our arguments for you, it implies that he's not going to be properly represented and he's not comfortable proceeding, which is why he's intimated that should the ruling not be changed to allow us to stand down till tomorrow, it implies that he's of the view rather that he's being treated unfairly and he would rather approach a court to have that addressed, Chair. And I do note that you're distinguishing the difference between written submissions and who exactly they're meant to assist, but it's client's instructions that he's of the view if his lead counsel is not here, together with us having not produced the heads before this commission, that he's not properly represented. And unfortunately, I can't comment any further than that because, as you do know, myself and my junior, my apologies, Chair, I forgot to put Ms. Brighton onto record. She's the third junior on the matter. And consequently, he's of the view that he's not willing to proceed, and he would like an opportunity to have this addressed before court, Chair.
May I ask an issue that we did not raise before? It is this. Why is it that there is no substantive application for a postponement with sufficient clarity? Now it has just been emphasized to us that, as I understand it, the main reason is the fact that lead counsel is not here. Why is it that no substantive application for a postponement on affidavit was brought?
Chair, I think for one, we did not anticipate that we would find ourselves in a position where we were not able to firstly consult with Mr. Matlala yesterday to get the additional information that we needed. Before we left, I did intimate that there is a document that is imported and it speaks to one of the bases upon which we bring this application, but it's obviously of a factual nature. He had to bring it here in the morning, so that's one element. The fact that we didn't anticipate not being able to prepare the replying affidavit. Number two, that then created circumstances that follow when we were not able to proceed and prepare the heads of argument on time to be before to serve on the evidence leaders and for the commission to have sight off. And so those are the reasons why we were not able to prepare ourselves on time to, or rather finally, we hadn't anticipated that Ms. Annaline would fall so ill to a point where she's unable to even be here in person. Because perhaps her being here in person as the lead counsel, we would have had a better argument, so as to say, and maybe have created a way for us to proceed to argue on a legal basis. But one thing I can say is that our instructions from client is that if his lead counsel is not here, he's not comfortable and he doesn't feel properly represented.
But the main reason throughout for not proceeding today is the fact that you did not have all the documents you think you require, and that was known for quite a while back, and that had nothing to do with Ms. van den Heever's being here or not being here. So at some point, especially because this morning a postponement is sought on the basis that these documents are not available. Your argument, that was the gravamen of your argument this morning. A reference to Ms. van den Heever not being well was something that was said in passing in your argument. Main reason, the fact that no replying affidavit had been filed, and also the fact that written submissions had not been filed. So the short point I'm making is that that's something that was known for quite a while. At some point, a decision should have been made that, seeing that we don't have these documents, and because we do not have them, we are going to seek a postponement. Let us bring a substantive application for a postponement. That's the point I'm making. The issue about lead counsel not being here arises because I have now directed that I want to hear, that we as a commission want to hear argument on the application, on the points in limine. That's when now the issue of Ms. van den Heever's absence takes center stage, and that has nothing to do with why this morning you argued that there should be a postponement. I hope you do get that distinction. Can you address me on that distinction in particular with regard
Chair,
to...
I do
just
get that.
let me finish. With regard to why there is no substantive application.
Chair, firstly, I'm just getting notes from a junior. Ms. van den Heever would have been prepared to argue the matter whether there were papers before us or not. That's the first point. Secondly, we didn't anticipate an instance where she would be ill and not be in a position to appear before the commission, which is why we were unable to prepare a written postponement. Because in the morning when we engaged with her and she was being rushed to the hospital to go and have her ailment addressed, we hadn't anticipated that she would not be here in person in time for us to then prepare a written postponement application. What I can assure is that the letter that you sent indicating that you haven't received a postponement application and will proceed. Absent of that application, we received it at around past 7 in the parking lot of the venue where this commission is being heard. And so, Chair, could we have prepared the postponement application? If we were in this position that we found ourselves in the morning the night before, we would have endeavored to prepare the postponement application. That's with certainty. But because this is something that happened to us in the morning and my instructions were to come before the commission and to ask us to postpone only till tomorrow, that's the reason why you don't have a written postponement application.
Now, I just want to get an idea of how things are to unfold in the event that I'm not saying we are adopting that stance, but in the event that we adopt the stance that we go ahead with the hearing of Mr. Matlala's application, how will things unfold then? Will you walk out? Will you withdraw as Mr. Matlala's legal representatives? I just want to get an idea of how things will unfold. Going further and saying, if we get to a point, and underline if we get to a point where, having heard Mr. Matlala's application, we do not grant it, and we go ahead with the hearing of his evidence in the normal course, with him, of course, being entitled to raise whatever privilege he may want to raise. So I want you to address me with regard to how things unfold, even looking ahead up to and including that furthest or farthest point.
So, Chair, as you rightly pointed out, it's either one of two options, which is the fact that it would be removed off the brief as his counsel and possibly even his attorneys. The alternative being that you would grant us another ruling, which is perhaps to say within a certain period of time, please ensure that you've served and filed this urgent application with your Part A and your Part B to review my ruling, and at which point would get the opportunity to do so. I must say I wouldn't have...
The application, the interdict, I assume that's a High Court interdict, so time frame with regard to that would have nothing to do with us. So...
Chair, when I refer to the time frame,
yes.
I'm referring to in terms of us ensuring that we've served you here and not what the High Court or the senior judge sitting would determine would be the ideal time for the urgent to be heard. That's just, again, ideas that I'm throwing out.
And may I, sorry to interrupt you. And as you are making your submissions, again, bear in mind, I started with two big ifs. If we reach that point, you should be aware that there will be no interdict in existence at that point. Which would mean that nothing stops the commission from going ahead and hearing Mr. Matlala's testimony.
Chair, as I said, that we hadn't foreseen an instance that the commission would possibly consider not granting us an opportunity to approach the High Court and address the application that we seek to be heard on an urgent basis. And if that is the case, I don't want to preempt what we would do if you decide not to grant us that opportunity. Because for me, it's a matter of you're either changing your ruling, allowing us to stand down till tomorrow. The alternative, you say, no, I'm not granting it, at which point the question as to whether are you going to rule to say, okay, since you've intimated that you want to have my ruling heard on an urgent basis and reviewed, then you are welcome to do so. I excuse you. But if you choose to proceed without excusing us and thereby Mr. Matlala, I would then ask for a stand down, because then there are implications on him that would affect us, i.e., for one, walking out, and who gets to walk out, and if for instance, counsel is removed off the brief, what are his options? And should he decide that he wants to walk out with us because he feels that he's being unfairly treated and is not being given an opportunity to be heard till tomorrow morning, with our undertaking being that whether Ms. van der Heever is here or not, we would have to ensure that I, being then the lead counsel, is prepared to continue and present before the commission. Then again, as I stated, we hadn't taken instructions with them. I think it would give us if you could give us an opportunity to stand on further, depending on what your ruling is, to engage with him and consider what the implications would be, because there are different implications should you decide to protest and want to walk away, and who gets to do the walking away and what those implications as well would be, Chair. I think it's wrong for me to preempt the instance where we decide, because walking away seems to imply that we are protesting, because we'll be walking away in protest. And if you walk away in protest, we've seen in previous instances what the implications are, and the client would have to consider that, and he'd have to give us instructions, Chair. I can't preempt to answer your question.
Thank you, Ms. Missy. Ms. Hassim?
Chair, I've been listening closely to my learned friend, and it feels like the reasons keep shifting for how we've come about to be in this position. Whether it's because the last submission that Ms. Messi made was that she would make an undertaking to proceed to deliver the argument in the absence of her leader. But if that is the case, then what would be the need then for the postponement? So, and for the urgent interdict? It's not entirely clear to me. It seems to me that, and I have some sympathy for Ms. Messi and Ms. Brighton, that juniors are placed in a difficult position where they have to step into the shoes of their leader. The leader has become unavailable for reasons not in her control. This is what happens in practice. And we are often called upon to step into the shoes of our leader on short notice and to be prepared to do so. It's not an easy position, but it is one you assume when you take on a brief and you're junior counsel. While I have sympathy for their position, it doesn't absolve them of their obligation to take the place of the leader. They were aware that Ms. van der Heever would not be available today. This could have been brought to our attention much sooner. One of the reasons that was advanced by Ms. Messi for the delay was the inability to consult with the client. That is not a ground, an adequate justification for a delay. That was in response to the chair's question about why didn't you bring a postponement application? Because it isn't the inability to consult on the law doesn't avail Ms. Messi on this. This is a legal argument that is to be made. So, and I've been instructed to put something on record. And I do so without having had the opportunity to make it, to alert my learned friend of this, because it only came to my attention now while I'm sitting here. And it goes to the point of the complaint by Ms. Messi of the inability to consult.
Is it not Missy? Is it?
Miss Missy. No, apologies.
Yes.
Maybe I've got soccer on my brain. It's only come into my possession. I'm instructed to put it on the record. And it's a message from the area commissioner for DC, Department of Correctional Services, Commissioner Khoza. And what he says, and this is received at 11:36 this morning, and as I said, I'm instructed to put it on record. I'm not going to read the entire thing into the record, just the factual part, not the comments, if I can put it that way. So the relevant part of the message is facts provided are not true. I am not even aware of the challenges advanced to the Commission. I think the challenges that were complained of. And then the next message, they consulted for 3 days and we are prepared to make concessions anytime because we understand the importance of the Commission. I checked with the head of the centre, Mr. Kabengu, on all these challenges. He also denied to have created any disadvantage to them. So that's a message from the Area Commissioner Khoza. And as I said, Chair, I'm just putting that on record. None of that actually changes the legal position that is before you. And the legal position is that a stated intention to launch an urgent application does not itself suspend this Commission's proceedings. Unless and until there is an order from a High Court that interdicts the Commission from proceeding, it can continue, subject, of course, to the Chair's discretion to adjourn. And maybe what I should do on that score is just refer the Chair and the Commissioners to 2 authorities. And the first is the Constitutional Court judgment in City of Tshwane Metropolitan Municipality versus AfriForum. And it's 2016, volume 6 of the South African Law Reports, page 279. And as I said, Chair, the judgment of the Constitutional Court, and the relevant paragraph is paragraph 74. And then as it happens, the other judgment I'd like to refer the Commission to is actually the Zuma judgment, but not the one I made reference to this morning, which was Justice Jaftet's judgment. It's the other judgment, Justice Kampepe. And the citation of that judgment is Secretary of the Judicial Commission of Inquiry into allegations of state capture, etc., versus Zuma. 2021, volume 5.
Sorry, there was a cough. Volume?
Volume 5.
Thank you.
SA Law Reports, page 327, at paragraphs 94 to 95. So with those, that's also, yes, it's Acting Deputy Chief Justice Kampepe writing for the majority. So with those legal submissions, Chair, we request that.
What do the cases say?
Let me take you to
You don't need,
the City of Tshwane.
you don't need to quote verbatim. You may just tell us the substance.
Well, it supports a proposition, Chair, that proceedings are not halted pending an intention to bring legal proceedings. It's not halted even if you have brought the legal proceedings. And of course, we know here there hasn't yet been a filing of an urgent application. It is a stated intention to file an urgent application. So that's the proposition. Well, let me just say, Chair, if I could just quote this one short aspect of the City of Tshwane judgment at paragraph 74. It reads as follows: it needs to be stated categorically that no aspect of our law requires of any entity or person to desist from implementing an apparently lawful decision simply because an application that might even be dismissed has been launched to hopefully stall that implementation. Any decision to that effect lacks a sound jurisprudential basis and is not part of our law. It is a restraining order itself, as opposed to the sheer hope or fear of one being granted that can, in law, restrain. To suggest otherwise reduces the actual grant of an interdict to a superfluity. That's a paragraph to which I referred the Commission to, Chair. So with those submissions, we request that the application from the bar, as it were, for a postponement should be dismissed, and that we should be in a position now to proceed with the questioning of Mr. Matlala as has been planned for some time.
I think the questioning would, if we do get there, the questioning would come after, depending on whether the legal representatives will indeed not be here, but the questioning would have to follow after Mr. Matlala, if he's all by himself, has been afforded an opportunity to move his application in person. So we won't, assuming that we are with you,
Yes.
we won't straight away go to the hearing of Mr. And again, assuming,
Chair,
I was once misunderstood by counsel, and we had an unfortunate heated altercation, he and I.
We don't want to have a repeat of that.
So-
I understand, Chair, clearly.
Yes.
Of course, and I don't wish to preempt any deliberation and ruling by the Chair and co-commissioners.
Yes. Yes.
My submission is merely putting forward the position of the evidence.
That actually takes us to a request that was made by Ms. Missy when I asked her how things would unfold if, and Ms. Missy requested a brief stand down for her to take instructions. I would assume you have no objection to that.
I have no objection, Chair.
Yes. Ms. Missy?
Chairperson, I did miss quite a bit of your interaction with Ms. Hashim because I was trying to figure out how we're going to reply to the submission that she's made. Am I going to be given an opportunity to respond to the message that she received? I want to ask that first.
Please do respond. Yes.
Firstly, Chair, the only thing that I will say is that those submissions were with regards to from Friday up until Sunday, the filing of our founding affidavit together with our consultation towards preparing a replying affidavit and the heads of arguments. It does not speak to any interaction prior to that. Secondly, if I'm being challenged on the submissions that I've made to this commission with regards to that on a factual basis, I do believe the timestamps of when I went in and went out, because I was present on Friday and I was also present on Sunday, can be looked at. That will show you how long I waited, where I waited, what happened, and ultimately, for example, at what time I got the opportunity together with my learned friend, Ms. Brighton, to eventually sit down outside of the Correctional Service Center and email the signed affidavit. So with that being said, Chair, I can only say that if I'm being questioned as to whether I'm misleading the commission or I'm casting a particular view about the Correctional Service Center, I'm not. I was simply saying that the commission is not aware, and any layperson out there is not aware that they have rules and they keep to their rules, and that has affected how we operated on Friday, Saturday, and Sunday. But if I'm being questioned, the timestamps, and I'm sure they have recordings, the times we signed in, as well as cameras to indicate whether I'm misleading the commission or not. That's as far as I can take it.
Thank you. There is no way that based on what we are told from the bar, from both sides, there's no way, seeing how contradictory the two versions are, that we can take a decision on that. And in fact, I think for present purposes, it's not even necessary for us to take a decision or to go there at all. Do you wish to reply to the rest of...
Chair, sorry, that threw me off a bit. Oftentimes when you are on the legal representative side and you're being called to question about whether you're lying or not, it does throw you off because it speaks to your integrity as a legal representative. I wanted to, because I believe in our earlier engagement, I wanted to distinguish between the position that's been taken by our client, Mr. Matlala, as well as the arguments that I made earlier on. Okay. So the arguments that I made earlier on are in relation to us, whether we can proceed and why we're saying we should stand out till tomorrow. The second element of it, having come back and taken instructions from clients, those are his instructions about how he feels in terms of us having to proceed. Should you insist that we proceed today and not wait till tomorrow? So there needs to be a distinction between the two. We're not shifting the ball post from this is what we were saying earlier on in the morning, and now we're changing and we're saying this here. What I spoke to mainly, now that we've come back after the stand down, is with regards to the instructions and his observation, how he feels about it. The earlier part still stands as it is, where you are asking us and we have to address you as to whether we proceed or we don't proceed, and you made the ruling that you made, which is that we proceed at 12:30. So I just needed us to make that distinction.
You do still need this stand down with regard to how things will unfold in the event that the decision is we are going ahead.
Chair, we still do need to stand down, but we had a discussion when we're hoping that it doesn't come off as if we're being hostile, as because if someone has underlying for us that, oh, so now you need to go and preempt, are you going to walk away from us? It gave that impression. But if
no, it's just wanting to know how things are going to unfold. There's nothing judgmental about it, and I have not observed any hostility. I just want to know how, if we do get there, again, underline, if we do get there, what's going to happen?
Chair, I would appreciate the stand-up. Chair, I would appreciate the stand down to just quickly take instruction from client, and then I'll come back with a response if you do decide to do otherwise.
Yes, thank you.
Noted, Chair.
Thank you, Ms. Hasim.
Chair, it's very important for me to make one remark.
Yes.
And it's in relation to the message that was received by the area commissioner.
Yes.
My instructions were simply to put it on record.
No.
I take no position on whether my learned friend, Ms. Missy, is misleading this commission or anything like that. That's not my intention, and I do not wish to be misunderstood at all to be suggesting that. It's simply an objective message that was sent through that I put on record. And I think perhaps what it is from the commissioner's side to say, we are not being obstructive.
Yes.
But the fact that it is difficult to consult with a client who is incarcerated, if any of us who have gone through that understand that it's a difficult process. And so I just wanted to make that clear.
An important takeaway actually from that text is this, as Ms. Messi was arguing this morning, I actually did think of the possibility of the commission engaging with the prison authorities to ensure that the difficulties Ms. is telling us about do not recur. Now, a good take-home or take-away from this text is that such an engagement will actually, there will be no resistance to the request that I already had in mind. Yeah.
Quite so. Thank you, Chair.
I will not indicate it. Yes.
Chair, my learned friend just highlighted something. I did speak about how we often use our cell phones for internet. We use our cell phones to get Wi-Fi through them to connect to our phones. If that request could specifically include that we have our cell phones, because that would really make things easier for us should we have to engage with him later on, to allow counsel at least one cell phone to come in with us. We don't all have to have our cell phones with just one cell phone, so that we don't have this issue of internet not being present, etc. Because what would happen is that, for instance, if we need to have a document and he's happy with it and we have to file it, it's just a matter of him signing it, we can scan using our phones. So, and then we would be able to send it immediately and wouldn't have all these issues of we don't have the internet, we need to leave, we need to come back, etc. So I request that you specifically include there that we are allowed to carry in one cell phone for purposes of having access to the internet.
That will be considered.
Thank you, Chair.
I'm saying considered. Let's adjourn. I will not indicate a time.